Okay, why don't we get started? I think folks are mostly in place. Let me start. Welcome to all of you, and thank you for joining us. My name is Preston Pugh, and I'm a member of the Executive Committee of Miller and Chevalier here in DC. The topic of the day, of course, is COVID-19 and its effect on the government contracting landscape. On behalf of my firm in the ABA, today we'd like to share with you a special opportunity, not only to hear from some of the best in the business, namely Jayna Rust, who will be our moderator, and Jason Workmaster and Alex Sarria, both my partners from my firm, but also a unique opportunity to hear from Isaac Natter at the Department of Defense, who's dealing with this changing landscape day by day and minute by minute. When my colleague Abby Stokes and I first came to Linda Maramba weeks ago to get this started, of course, Linda leads the section. We were excited about the possibility of presenting a panel that not only spoke about the COVID-19 issues in theory, but also from real experience. And not just an industry perspective, but critically the government's perspective too. So that's what we're presenting today. By way of introductions, I'd like to start first with Isaac. Isaac Natter is an attorney in the Department of Defense, Office of the General Counsel, in the Office of the Deputy General Counsel for Acquisition and Logistics. Isaac was born and raised in the DC area and has been a federal government attorney for 14 years, including 12 years with the Navy Office of General Counsel. Isaac provides advice and guidance to the Undersecretaries of Defense for Acquisition and Sustainment and Research and Engineering. His portfolio includes defense research, grants, SBIR and STTR, technology protection, supply chain, sustainment, and acquisition fraud. Welcome to Isaac. Jayna Rust, from the law firm Thompson, Coburn, and also one of the leaders of the ABA section, advises companies, transportation authorities, and other entities regarding their rights and obligations when doing business with the federal government. She works with clients on claims, protests, and compliance. She also counsels clients on contract and grant administration matters. Combining her work in both contract and grant administration matters, she also advises clients on developing and applying policies and procedures that meet 2 CFR Part 200, the Uniform Grant Guidance procurement requirements. Welcome to Jayna. Jason Workmaster, one of my two partners here, is a partner at Miller & Chevalier and has assisted numerous clients with responding to the unique issues that arise in contingency contracting and has litigated contract disputes and False Claims Act cases arising out of such environments. Many of these cases have involved complex cost allowability, cost accounting, and breach issues. He also has significant experience with excusable delay and termination issues. And he was also, I'll brag on him for a second, was one of the government contracts lawyers of the year last year for Law 360. Welcome, Jason. Alex Sarria is a member in Miller & Chevalier's government contracts group and also my partner, where he represents contractors in high stakes civil litigation, including contract disputes, bid protests, prime sub disputes, and contractor on the battlefield lawsuits. Alex also advises contractors on a range of cost allowability and compliance matters, such as domestic sourcing and supply chain requirements. And with that, I'll hand it over to Jayna. I think, Jayna, you may be on mute.
Can you guys hear me now?
I can hear you. Yes, thank you.
Thanks, Preston. Thanks again to you and Abby for really putting together the legwork on pulling together this panel so quickly. I really do appreciate it, and I'm glad to be here moderating. So without much ado, I'm going to go ahead and get started with the only caveat of saying, if you have questions, we would love to answer them today if we have time. So please send any questions you have for the panelists to events@milchev.com. It was in the registration information you received. Again, events@milchev.com, and that will get funneled to us, and I'll try to weave in questions as I can throughout or at the end, but go ahead and send those there. And let's go ahead and get started. And Isaac, I'm going to turn to you first and ask, what are some of the top issues you're seeing today in your office? What are the top 3 issues or topics you're dealing with that you weren't dealing with maybe a month ago?
Thank you, Jayna. Before I answer, I'd just like to mention the usual government disclaimer that I'm speaking in my own personal capacity. I'm not doing this in official capacity. I'm not representing the Department of Defense or the U.S. government, and so any opinions are my own and not the government's, and none of this is binding on the government. With that out of the way, I think it's important to, in addressing the 3 issues, it's important to keep in mind that the department is tackling a lot right now. It's not just contracting, that's a small piece of everything the Department of Defense is doing in response to this pandemic, from securing borders and providing medical support to airlifting supplies and protecting the warfighter and their families. And in terms of all of it, it's important to remember that right now we're figuring out how to tackle new missions while at the same time continuing our existing missions. They don't go away just because we have this new crisis. That being said, within the realm of contracting, the 3 big topics issues I'd say that I've personally been dealing with have been examining ways to provide flexibility to contractors as much as possible while ensuring that requirements are being met, contracting for supplies, particularly personal protective equipment, pharmaceuticals, and things of that nature, both to meet the military's requirements and to support other federal agencies. And then questions about the essential workforce, who's going to work, who's staying home, and how to make sure that people that are living in areas of stay-home orders are able to get to work.
Thanks, Isaac. And we'll come back and touch on some of those topics later for those of you guys who are attending. We're not going to let him get off the hook that easily on those topics. But Jason and Alex, what about you guys? What are the top 3 questions you guys, as outside counsel, or as folks working with contractors, what are you guys seeing that you weren't seeing about a month ago? What are your top 3 issues?
Sure. From the contracting community, I think right at the top is, how can I help? We've seen this before in response to national emergencies. We saw this after 9/11. We saw this with the Iraq War. Of course, this is a very different thing. This is where we're fighting a biological war in our own backyard. And so, but there has been a lot of course, the government is moving quickly to fight the pandemic. And of course, we've seen those kinds of questions that we've seen before with respect to, contingency operations, emergency operations. So I think I'd put that first. And then the second is as Isaac was just saying, the business of government continues to go on. And, folks, I think in this early, we're still in the early stages of this. Next bucket of questions that we're getting, how do I keep on keeping on? How do I keep performing? First of all, just with respect to the performance impacts that this is creating, just how do I physically get stuff done with my workforce at home, and just in a very, very difficult, situations. And then of course, behind that, just how do I keep performing? What do I do with the impacts that are resulting from that? What do I do with increased cost? What do I do? That I think that's, again, for the most part, the government is wanting to keep things in motion as much as possible. I think we all understand that for non-essential things, things that are not directly tied to fighting the pandemic, I think we can expect to see a lot of that slip to the right. So our clients are beginning to deal with that reality. A number of procurements I think are going to be put on a back burner. Money's going to get shifted around, that kind of stuff. But then for the contractors that are just continuing to get work done, what are they going to do with the cost impacts What are they going to do with, compliance issues that are still, the cyber requirements are still in place? What do you do with cyber requirements now that you have a remote workforce? Those kind of questions. So I put that in the next bucket. How do I, keep performing, and how do I begin to mitigate, the performance and cost risks associated with this extraordinary situation? And then I think in the third bucket, what if I can't perform? That's, I think, for everybody, especially in this early going stage, and we're hopeful that this continues throughout the response to the pandemic. I think there's a lot of desire to work cooperatively with the government. The government wants to work with contractors. Contractors want to work with the government. But, thinking ahead, what if I can't perform? My workforce isn't there. Beginning to think about things like excusable delays, and if you're facing termination for default, that kind of question. Beginning to think, how do I position myself for if the worst happens and I can't perform? So those are the buckets. How do I help? How do I mitigate risk where I'm continuing to perform? How to prepare myself if I can't perform down the road?
Yeah, just a few things to add there. I mean, I think, to offer up an analytical construct that we've been using as we've been discussing these issues, it seems like, at least up until this point, we've already had really 3 phases in the life of the impacts on government contractors, with a likely 4th phase, hopefully far down the road. But, phase 1, as both Isaac and Jason have noted, it's really the questions there are focused on practical questions about how to move my workforce, into a telework model, whether my business or my employees are deemed essential under federal guidance, and what's the interaction between that federal guidance and state and local orders, for stay-at-home orders. An example there is, a ventilator manufacturer, which I think we all recognize is a pretty critical item at this point in our ability to recover as a country. This is a US-based manufacturer who has suppliers in various states scattered throughout the country, and depending on the state in which certain suppliers were, there were some suppliers who were balking at whether or not they were deemed essential, and had to go and send their workers back into the factory to produce these critical parts that ultimately fed into the ventilators. And then, the second phase, which I think we are living at, at this very moment, is, as Jason mentioned, how do we weather the financial storm? How do we maintain continuity of operations? And I think on that question, I think the government actually has been very good about putting guidance out there, right? There's a March 20 OMB memo, and most recently the March 30th memo out of the Department of Defense, which is written in terms of guidance to contracting officers in terms of how to fit this unprecedented situation into the normal construct of government contracting. So how to look at things like questions about excusable delay, how to look at requests for equitable adjustment, and making sure that you're making reasonable decisions on things like that. And I think this phase most likely has the longest shelf life, even though some of this is starting to become routine in many ways. The longest shelf life being, I think, catalyzed by all of the money that's being pumped into the system, right, into federal contracting. So the CARES Act and other procurements and opportunities that are being publicized at the moment. The questions I think that we're likely to see in this phase will likely persist. Phase 3 hopefully is something that doesn't come, right? But as Jason mentioned, you will start to see questions about delayed procurements and potential stop work orders, or performance problems that contractors are experiencing. And what are the impacts there, right? Are contractors able to claim excusable delay? What kinds of costs are recoverable during a stop work period? And how do you segregate the impact of the work that's been stopped from the work that hasn't been stopped if it's only partial? And then phase 4, I think, is sort of what we all recognize is, the inevitable oversight that the government has to conduct when you're spending this amount of money in such a rapid, short time period, right? So, things like audits, OIG investigations, and the like. That's most likely the fourth phase, and we thankfully haven't started to see questions yet, but one would expect that those are on the horizon.
Thanks, Jason and Alex. And like I said to Isaac, I'm not going to let you guys fully off the hook on those points. And some of those things, hopefully, we'll be able to come back and discuss in further detail today. But one of the other things I wanted to give attendees some previews on that we'll hopefully talk about as well, in addition to some of these items that Isaac, Jason, and Alex mentioned, we should be able to have some time to talk about the CARES Act, in particular, Section 3610 and the Defense Production Act. So we'll talk about those, as well as tie in some of these ideas that Isaac and Jason and Alex have just talked through. So one of the things I did want to go back and touch on, Isaac, was you had mentioned that one of the things that you've been dealing with is what's essential work and determining what is essential. And, you know, Jason and Alex touched on that as well from the client side, from their client side of, you know, figuring out what's essential in each state. From your perspective of what you've been seeing, how is your agency determining what efforts are essential or critical infrastructure?
That's a good question, Jayna. I think what's important to remember is that, at the Office of Secretary of Defense, at the big DoD level, where Undersecretary of Defense for Acquisition Sustainment, Lord, is working, we're not, at that level, they're not saying we're going to decide what specific things are essential or critical. Those are the responsibility of the components and the contracting organizations within the department that are exercising and administering those contracts. But what the department is doing is providing overarching guidance to the components to help make those determinations. And essentially what that guidance says is efforts that support the essential products and services that are required to meet the department's national security commitments are the types of things that we consider essential. So essential critical infrastructure includes contracts and subcontracts that are supporting developing, producing, testing, or sustaining weapon systems, or supporting training and equipping military forces. Whereas other things that, while good to have, aren't directly necessary for national defense or military commitments, such as rural welfare and recreation or office supplies. Those might not be essential critical infrastructure. However, that leaves lots of gray areas, because an entity can have a military contract and parts of it could be essential and performance other parts could not be. And so that discretion ultimately comes down to the components to communicate with their contractors to say, we've determined that what you're doing is essential or not essential, and here's what we're looking for from you. So for example, custodial services. You don't have to have custodial services to fight a war. However, given that we're in a coronavirus pandemic, I would assume that to the extent we have people coming into facilities like I am, we need to maintain some level of cleanliness to be able to support the warfighter through our efforts. So to some extent, that's a essential critical infrastructure, but maybe not every single service provided by custodial services in the regular environment. Also, we want to make sure that to the extent components are identifying essential services, the solicitations for those services and the contracts for them need to have the right DFARS language, clauses 252, 237, 7023, and 7024. And to the extent they don't, but it's going to be deemed essential, the contracting officers are modifying those contracts to put those clauses in.
Thanks, Isaac. And I will say from my perspective, that's something I think I'm probably seeing as the components are making those decisions. As some of the client contracts that we've seen, there's been some suspension of just parts of the contract and not the full contract. But I wanted to turn to something that Alex mentioned earlier as well, which was the differences in the shelter-in-place orders, or the difference in localities and how they're interpreting what is essential or not. So from your perspective, how have you seen federal agencies responding to different local shelter, different state or local shelter-in-place orders or stay-at-home orders, whatever they're being called there? in areas where contractor personnel are continuing to perform on site? And related to that, what is the agency doing to facilitate continued on-site work for employees or contractors in those areas?
From the Department of Defense's perspective, and speak to other agencies would be primarily anecdotal, but from the department, what we've been doing is looking at the stay-home orders, and from the ones I've reviewed, and I haven't reviewed every single one, but I've reviewed a bunch of them, they all consistently have exemptions for things like government functions, critical infrastructure, national defense, etc. And in my opinion, that language permits the Department of Defense to continue performing the functions it deems are necessary for national defense, including having personnel work on site or travel to and from work. Again, in my opinion, not speaking for the department, I don't believe that states have the power to shut down federal agencies or tell federal agencies you can't operate functions. And I don't think any of them are trying to do so. So to that extent, we have been communicating to our military members and civilian employees within the department, if performance on site is necessary for you to work, you are permitted to go to work. Managers and supervisors and commanders are allowed to direct that people report to work sites or otherwise travel for work. We're encouraging telework to the maximum extent possible, but there are people who cannot do their jobs while teleworking. We've started providing what we call safe passage letters for employees and military members to carry with them that essentially says, I'm a DoD employee, I'm performing essential critical functions, and here's my CAC card in this letter, you should allow me to go to work. However, again, in my opinion, that's really more of a nice to have security blanket type thing, because I don't think it's really necessary. If all of the stay-home orders that I've seen have had provisions that allow people to go to medical appointments and go to the grocery store and do other things like that. So if someone stopped and they're going to the grocery store and not work, it's not as if they have a letter saying that the grocery store permits them to go there. And I believe the same thing would apply if someone stopped going to from work, that as long as they explain that they're going to a job that meets one of the exemptions in the stay-home order, they should be fine. However, it doesn't hurt to provide these letters. For contractor personnel, however, that's a ongoing discussion. And again, speaking to my personal view, it's not appropriate for the government to give some sort of letter, safe passage memo, or ID card, that nature, to contractor personnel, because we're not their supervisors. The government shouldn't be getting involved in how contractor staff or manage their performance, including where the workers are. The government can communicate to the contractor as a corporate entity that the services need to continue, and it's up to the contractor to determine how to best continue performance, be it on-site or remotely or in some other fashion. And then if a contractor, the company, wants to give its personnel some sort of safe passage type letter, explaining that they are supporting the Department of Defense and they're doing mission critical work, et cetera, they're welcome to do so. But in my opinion, it's not something that should be coming from the government directly to contractor personnel, because that would be akin to personal services.
And just to sort of corroborate that anecdotally, I mean, the example of the ventilator manufacturer I gave earlier, I think sort of is an example of how what Isaac just said has been playing out in real time. What ended up happening there is we were able to connect this company with folks both in the White House coronavirus task force, but also with some folks who are sitting on FEMA personnel who are sitting on DHS's CISA coronavirus task force. And essentially what we got was very consistent with what Isaac said, but on a couple of levels. One is the FEMA folks that we spoke to made the point that the federal government, at least in the current situation, is not going in and telling individual companies that they fall within an exemption of a state order. Point one. Point two, they're also not in the business of telling states how to interpret their own orders. And so the advice that we got, or the guidance that we got from FEMA for this particular client was, if you help us find either the suppliers or the leaders within the state who are either uncertain as to whether your workforce or their workforce is essential, or their employees or their operations are essential to performing the broader contract or the manufacture of these ventilators, we can help by coming in and having a discussion and explaining the importance of the ventilators, and sort of persuading them that, hey, they are probably on safe footing. But the federal government's, the message was pretty clear. The federal government is not going to come in and tell anybody what to do per se. So there are a couple of ways in which contractors can work through issues like that, right? One, Isaac's already mentioned, and I think a lot of the folks on the call are probably using this technique, but giving workers a letter that says, hey, I'm performing work on a federal government contract that has been deemed essential or falls within exemptions to state stay-at-home orders. That's one approach. The other approach is sort of, if you're running into a bigger issue where you have a supplier on the ground who just won't budge from either concern that they would be violating a stay-at-home order, or a position that they don't think that their workforce qualifies as being essential for one reason or another, is to try to go directly to leadership within the state, so AGs, governor's offices, and that sort of thing. And that's also, I think, another way to get at these issues that are starting to hopefully work themselves out now, as we are in like week 3 or 4 of this.
Yeah, I mean, I think the bottom line to a lot of that is simply from a legal perspective, will an entity, a contractor, be able to continue work, as a legal matter? Are they essential? Are they not? I think that for all the reasons that Isaac and Alex have already talked about, the states and the feds, I think that legal aspect of this will get worked out. I think the more tricky thing is going to be, if you have individual workers who say, well, that's all well and good, I'm staying home. That's going to, and that results in some performance impacts. I think that's where, the contractor could be put in some, difficult, position of having to make some difficult decisions when individual employees start, to the extent individual employees start making kind of determinations for themselves about whether they're going to obey the state work order, stay at home, shelter in place order, or not.
Thanks all. And related to some of the performance issues that contractors are going to encounter, one of the other things that Jason, you had mentioned on the top 3 issues that you've been dealing with lately was that contractors are asking about what to do, with the impact, what to do with some of the expected costs they're going to incur. So what are your thoughts on right now as contractors are starting to incur some of these costs? Certainly not going to be able to identify exactly at this point what, the total amount of the impact of anything is that, right now. So what are your thoughts on how contractors should deal with, addressing these costs?
I mean, the first thing, of course, is to capture them. And that's always the case. Whenever you're talking, of course, we're talking about depending on the kind of contract you have. If you have cost reimbursement contracts, fixed price contracts, T&M contracts, that's going to be different from each. If you have on your cost reimbursement contracts, you should be okay. I mean, you're entitled to recover your allowable, reasonable costs. We could see, we saw this coming out of the Iraq War. Alex and I have a lot of familiarity with litigating, reasonableness of cost cases coming out of the Iraq War. We could see that. I think we could see that again. So, documenting the rationale for why you're incurring costs, why your costs are going up. I think that's going to be, we saw that after the Iraq War. We saw that after other emergencies. I think that's going to be important. That's good contracting hygiene anyway. And as Alex said, that's kind of phase 4 down the road. There is always the Monday morning quarterbacking aspect to all this to these kind of situations, and that's going to put you in the best place to document. But again, if you have a cost type contract, you should be able to recover your allowable, reasonable costs. we have had some questions come up. If you're recording, what does that mean for things like, recording time? Should you be creating new charge codes? If you have folks that are now at home and maybe there's, you get into this question of, are they as productive or as they were under normal circumstances? Should you be creating new charge codes to capture, quote unquote, idle time? Our advice there has been, be very careful. Look at your contracts first before you start creating codes like that. To the extent that your contracts, whether it's cost reimbursement or otherwise, that allow you to charge time that your folks are available to work, regardless of quote unquote whether it's productive or not. You need to think long and hard before you start creating new codes to capture loss of productivity. With respect to under your cost type, under your fixed price contracts, of course you'll be looking to your changes clauses. And of course that could be different whether you're looking at your commercial item contracts or your contracts with the standard changes clauses out of Part 43. But again, it's going to be critical to capture the extra cost, and again the gold standard of being able to recover these costs down the road. The other thing we're telling clients is, good communication with your contracting officer. The gold standard for being able to recover additional costs is going to be able to demonstrate that you are incurring these costs in response to contracting officer direction. That's the gold standard. Backing off from that, you start talking about direction from your COTAR, the technical people. That starts to get a bit murkier. I mean, we all know that from having dealt with REAs and claims under normal circumstances. That's always the case. But as the further you get away from contracting officer direction to say, well, look, I just incurred this cost because there was a pandemic. That's getting a little bit further afield. But you're going to want to begin documenting, and again, not just what the cost is, but the rationale for its incurrence. It's going to put you in the best place down the road.
Yeah, just one quick observation there. I mean, Jason mentioned setting up separate charge codes so that you could segregate costs and ultimately justify them. I mean, what we've been telling clients is, do that, go through that exercise as though each and every one of those buckets of cost is going to be audited down the road, right? And I think an essential component of that is not only setting up the charge codes and describing them, as Jason has said. I think all of that is excellent practice, but also making sure that your personnel and your workforce understand what each charge code's rationale and what it should be used for. I think, setting up the construct is extremely helpful. But if, as we all know, I think is sort of human nature, if there's a charge code that's being overused or, improperly used, making sure that, either through training or through messaging, you give your contract employees, your contractor employees, the appropriate guidance to figure out when to use certain codes and when not to use certain codes. That also can go a long way to ultimately helping you recover costs on the back end years later.
Yeah, and one other thing I just throw in there is that a particular cost, that we've gotten questions about is, changes to PTO. I mean, folks who have, expanding their PTO policy in response to the pandemic. Normally, under cost type contracts under the FAR, cost principles, you can recover PTO as goes, as fringe, as long as it's a quote unquote established policy, and working through what that means in this particular context as you're making a change, to document. And again, gold standard would be, contracting officer sign off. That this change, as a function and can be characterized as an established policy, so that you're not in a position down the road where an auditor's looking at that and said, "Whoa, you made this massive change to your PTO policy and it's not established, and so we're not going to allow the cost." So again, that's just another particular example of what we're seeing.
Thanks, gentlemen. And related to that, I wanted to talk a little bit more about some of those related costs. Preston and I, when we had talked about doing this seminar or webinar, we had tossed around including a whole section on labor and employment and some of those related costs. But we wanted to keep this really focused on government contracts as much as we could. But one of the things that came up after we decided to do this was the passage of the CARES Act, which included Section 3610. And that does relate to contractors, definitely, and some of those costs that you guys were talking about. And Isaac, I know you've been more familiar with this on the back end, I think, than some of the contractors and outside counsel are. So, you know, those of us on the contractor and outside counsel side, I think we're starting to get questions about this, but I think you're more familiar with this. So can I pass this over to you to kind of give folks a little bit of a background on what Section 3610 of the CARES Act involves?
I guess you can. I'm willing to consider it. No, so basically, Section 3610 in the CARES Act gives federal agencies, not just the Department of Defense, but all federal agencies, the authority to unilaterally modify contracts without consideration to allow contractors to invoice and be reimbursed for paid sick leave and other types of time off they pay employees during the pandemic, pursuant to certain restrictions up to certain amounts. Essentially, it's a way for the government, if it chooses, so it's an authorization, not an obligation, but it would allow the government to modify contracts so that contractors can keep their workforce in a paid status even though they're not working as a result of the coronavirus pandemic.
And Alex and Jason, what are you guys seeing as far as questions related to this, if any, yet? Or is this something that you're just kind of waiting to come down the line, or something that you're going to be bringing up as a potential for your clients to raise, given that this is, again, not a mandate, but is something that is optional?
I mean, I see this as something that, you know, as contractors are contacting us, as we're talking through the topics, I think there's going to be very high on the list of things that they're looking to recover. So it's going to, you know, provide an extra level of protection, again, cutting across contract type to allow contractors to recover. I think this could prove to be a very useful tool for contractors. And, you know, to following up on what we were discussing before, you know, early engagement. You know, in almost all situations, I'm an advocate of early engagement with the government on issues like this. And so if you see issues coming up, you know, beginning to float them and beginning to socialize them with your contracting officer, I think is almost, you know, 9 times out of 10, that's going to be the way to go. Because again, also here in these early phases, I mean, it seems forever, but, you know, it's only been, you know, a couple weeks now that we're into this. And I think there is a lot of goodwill, both on the government side and on the contractor side, to try to work through these issues in a cooperative way. And I think taking advantage of that in the early going as issues come up is going to be it's going to be in the government's interest and in the contractor's interest. So with this authority, and as with respect to any of the existing authorities where we're talking about changes or, you know, allowable costs under Part 31, I think engagement with the contracting officer early on, as you're beginning to experience the cost impacts, I think in this kind of situation, the last thing you want to be is, of course, there is the 6-year statute of limitations under the Contract Disputes Act that we're all familiar with. Don't wait 6 engage on these issues earlier. You're going to be as a contractor, you're going to be in a better position. And again, I think the government's going to be in a better overall position.
I couldn't agree with you more that this is something where contractors need to engage early on with contracting officers. There's a lot of unknowns about this authority and how it's going to be implemented. Defense Pricing Contracting, DPC, is still developing policy on how it's going to be implemented. And there's other ways that contractors can work with contracting officers to get relief outside of this authority. I think it would behoove contractors to communicate with contracting officers what their needs and concerns are now, and to tell them, if we're not able to keep people in a paid status, we're not going to be able to continue performance following the coronavirus, whatever the case may be. and trying to work some sort of equitable adjustment or something like that. Again, my opinion, but those are strategies to consider, not just waiting back, holding back, and assuming that this is going to get you paid for everything you pay to keep contractor personnel in place when there's still a lot of unknowns about this authority.
Yep, I couldn't agree with that more. And you just put yourself in a better position as the contractor. You know, again, I think as we started the discussion, you know, it's interesting. My mind goes back to like the shutdown. This is not a government shutdown. You know, this is the government is continuing to work and wants to do work, and contractors are still under, you know, contractual obligation to do work for the, you know, for the most part until you get a stop work or a termination. And so you want to, you know, what we're talking with our clients about is just being in that position where you can keep performing. Everybody wants that, you know, and you're in a much better position. You're almost certain to be in a much better position there than sitting back and getting yourself into a place where you can't perform and then trying to argue excusable delay, you know, and in that, you know, that, you know, you miss a deadline or whatever, and then you say, well, I'm excused from performance because, you know, because of the pandemic. You still have to make the showing that the delay there was caused and the result of the pandemic response, and you could get into some issues there of whether was it the pandemic or was it your failure to manage well, and that's not a place you want to be where you're, you know, there you're trying to stave off a default termination. So again, I think we're all singing from the same sheet of music here. Early, open engagement is almost certain to be the better call.
I think it's important too to highlight something Isaac just said, right? So DPC is working on, so the March 30th memo that came out of the office, the DPC office, indicated that there would be guidance coming out on 3610 as soon as practicable. And I think, you know, that'll be something to keep an eye out for. Certainly there are some open questions left by just the statutory language. And if you're issue spotting it, I think, you know, a couple things jumped out to me when I first read it, which is one is, you know, contractors will be reimbursed at quote unquote minimum contract billing rates. That language, I think, at least for me, makes me think of a time and materials or a labor hour contract, but query what, you know, the minimum contract billing rates might mean under a fixed price contract or just a pure cost reimbursement contract where you don't have billing rates per se. You know, another question here is, you know, it provides relief for any leave paid by the contractor or allowed by the contractor. You know, hearkening back to something Jason said a minute ago on the cost principle that makes fringe benefits allowable, query whether for these costs to be reimbursed, you know, the leave provided by the contractor needs to be consistent with their established policy, right? Or is that something that, you know, years down the road would be susceptible to second guessing, you know, by an auditor or somebody who might say, well, sure, you were providing leave in response to a modification to your contract made pursuant to 3610, but that didn't relieve you of your obligation to charge the government for only allowable costs. And so the leave that you provided, you know, is not consistent with your established policy, and therefore it's not an allowable cost. You know, a couple of other, you know, questions is the work needs to be in an approved government site. You know, is that the place of performance spelled out in the contract, or is that something that, you know, as contractors work through this issue, as Jason and Isaac are mentioning here, that, you know, just a detail that you want to hammer out with your contracting officer as this modification is being made, is that approved site where you are actually performing the work currently. And then, you know, subject to that approved site being subject to closure or other restrictions, right? You know, looking at that, one would think that that would apply to these stay-at-home orders for non-essential employees, but and workers who may not be healthy or concerned that they are maybe have the virus or coming down with the virus. But you know, the restrictions again are not one for one in every state, right? There's not uniform guidance. And so understanding what, you know, again, what those restrictions are, what those other restrictions are might be, and getting clarity on that, I think is something that not only be helpful to see from DPC, but also if those are lingering questions on a particular contract for a company, going forth to your contracting officer and just sort of working through each of the questions you might have.
Thanks, Alex. And we've started to get some questions in, and I hope to be able to tie those into some of our future questions. We've got about 13 minutes left, though. So if anyone else has questions, please do send them in. The email address should be visible on your screen. If not, it's again events@milchev.com. And one of the next questions, though, I wanted to turn to was another kind of hot topic, something that's been percolating in the news since we had started the idea to, or floated the idea to do this webinar, and that was the Defense Production Act. So what questions are the three of you guys fielding related to the act? And related to that, what are some of the things that you wish that folks on your side or the other side or clients understood about the Defense Production Act that maybe hasn't been clear? And Isaac, I'm going to go ahead and pop it over to you to start talking about what you're seeing first.
Oh, you're picking on me again. All right. Well,
I've been told I pick on people a lot.
I don't mind. I can take it. So we're getting lots of questions about the Defense Production Act in terms of what can the DoD do under the Defense Production Act. Can the Department of Defense place rated orders for personal protective equipment or medical equipment, ventilators, pharmaceuticals? Can the Department of Defense use the Defense Production Act to somehow order large quantities of coronavirus test kits? Those we've been handling all those questions and sort of explaining the Defense Production Act to a lot of people. I think that particularly Title I, and I think that what I would really want to explain to both my clients and to other people asking this is that the term defense and Defense Production Act does not mean that this is something that the Department of Defense automatically or necessarily has authority over. In this case, HHS actually has the authority to place rated orders and to place ratings on orders for health resources. And so Department of Defense doesn't have rated contracts for personal protective equipment or anything like that. And in order to start rating its contracts or placing rated orders, the Department of Defense would have to get that authority delegated from HHS. So while we're also a big player in the personal protective equipment market, and we've got large numbers of military treatment facilities that need this equipment, we're in the same position a lot of others are in terms of placing rated orders, and being Department of Defense doesn't automatically give us that authority to start doing that in Title I.
Yeah, on our side of things, we're seeing similar questions, right? It's, what do I need to do in response to a rated order? What does it actually mean? How do I have to allocate work? What are the differences between a DX rating and an DO rating? Really just questions about the nuts and bolts of the DPAS regulations and other regulations that implement the Act under Title I. As Isaac mentioned, there's the 2012 Obama administration executive order that delegated authority, I think that Isaac's referencing, to issue rated orders for health resources to HHS. And so one question I think is that some clients have been asking is, how do I educate up, right? How do I engage with particular agencies that I think I can help, that I'd like to be able to do business with and support, and how can they start to use the authority that seemingly they do have to place those rated orders? I think, in the category of things you wish, others would understand about the law, and I agree with Isaac. I mean, I think there's just a lot of misunderstanding out there in the press. Particularly, there's a New York Times article within the last couple of days here that was sounding the alarm about the Department of Defense using the Defense Production Act hundreds of thousands of times, and yet they're not willing to do it for the coronavirus. I mean, I think that falls squarely into some of the misunderstanding that Isaac was referencing. But one
Believing
area
the
where,
media would ever get something wrong. That never happens.
but one area I think here that hasn't been getting a lot of attention is, there are provisions of this act that allow agencies with delegated authority to not only place rated orders and allocate force contractors to allocate resources pursuant to Title I of the Act, but under Title III, there are a number of incentives and such as loans and purchase commitments that agencies can make under the auspices of expanding the domestic industrial base's capability to respond to a national emergency like this. And understanding what the limitations are there, there are some funding issues and sort of, what color of money is available to actually make those types of purchase commitments under Title III. Certainly those are important questions that, government needs to answer. But, that's one area where it seems like from a policy perspective, there is this existing authority under the DPA that may strike the balance that the administration is looking for in terms of not wanting to seem like we are, government is somehow taking over industry, but also accomplishing the very real objective of getting industry ramped up here with the necessary financial assurance that's available under the DPA.
Thanks, Alex and Isaac. One of the things that has come in as a question, Alex, I wanted to send back to you to quickly kind of answer before we go on to another topic, was you had mentioned earlier that you kind of foresee that there are 4 phases of dealing with this. And I think some folks, the audio may have been cutting out when you were talking about them. Could you real quickly just summarize what those 4 phases are again, and we'll use that as a jumping off point for the next set of questions?
Sure. Phase 1 was just sort of companies, I think, working through the practical questions of how do I transition to a telework model? How do I reconcile federal guidance on what's essential with the state and local orders? Phase 2 was really just, I think, where we are right now, which is understanding how to maintain continuity of operations, how to recover increased costs to the extent that's important to keeping your work and your contract performance at the status quo level. Phase 3, I think, is what we're starting to see a little bit of, but not yet what I think the government contracts bar foresees down the road here, which is questions about excusable delays, suspension of work, stop work orders, potentially terminations for convenience where that makes sense for the government. And then phase 4, I think, is that inevitable oversight that's going to have to occur here when the government is spending this amount of money, as quickly as it is. So things like investigations, audits, that sort of thing.
Thanks, Alex. And one of the things that I think it kind of ties to that 4th phase is what compliance concerns do you and Jason have that you think the pandemic might be highlighting or creating? And this may be, related to Jason's first point that he said that, he's been dealing with more of the how can I help? So folks who are getting into the side of helping on addressing the pandemic, what are some of the compliance concerns that you guys have related to that? And for the folks who've been submitting questions, I want to let you guys know we're planning on going past 3:30 to help answer some of those questions. And we'll kind of get to those as we talk through these last few points from Jason and Alex and Isaac as well.
So on the compliance piece, I mean, there's been no, Alex was mentioning the Defense Production Act, but so far there has been no wholesale waiver, of all the compliance requirements that we, again, it seems like a different lifetime at this point. But I mean, the cybersecurity and CMMC out of DoD. I mean, the latest word out of DoD is that CMMC is full speed ahead. So, complying with the cybersecurity requirements, that's not going away. We still have, and again, right before all this was happening, there was a public meeting that DoD held when public meetings were still legal, in-person legal meetings, and on 889. So, I'm sure folks on the line are familiar with, the Section 889 out of the NDA from a couple years ago has already imposed a ban on the government procuring certain Chinese technologies that we often refer to as the Huawei Ban. Huawei is one of the identified companies in the legislation. That rule went into effect this last August, and DoD held a public meeting just a few weeks ago on the upcoming ban, which is going to be a ban on the government doing business with an entity that uses the identified equipment, Huawei and other Chinese entity equipment. That's coming, and that's still on the books to come into effect in August. And with all of the telework that's now in place, the questions about cybersecurity and compliance with, both the existing Huawei ban, as I'll call it, and the upcoming Huawei ban, that's still something that contractors have to be worrying about. And if you're a new entrant into this marketplace, that's that kind of requirement, is potentially a big deal. So that's still, those requirements are still there. Domestic preferencing, Trade Agreements Act issues, those issues have not gone away. We've got some questions on those subjects as well. I mean, there is authority. If the contracting officer makes a determination of non-availability from either the United States or a designated country, there could be some room to work there. But I mean, those are issues, again, the advice there is work with your contracting officer, because until the trade agreement, if you have an existing contract that has the Trade Agreements Act clause in it, that's still there. And until it's removed, there's still, as a technical matter, there's a requirement to comply. So, those issues are not going away. And in fact, because of the sensitivity of and again, this was right before all the shelter in place and the virus really broke out here in the last few weeks. But the administration, there was just another $1 billion that has been, the president has signed legislation to replace the government's own technology from these designated companies. So I don't see that changing. And if anything, there was, in the current environment, with the political situation with China, I don't see that changing, virus response or not. So again, our message to clients has been, those issues you still got to be thinking about and working with your contracting officer on.
Yeah, I think the domestic sourcing requirements is probably one that I think has a pretty strong parallel to what we've seen during contingency contracting over the last decade or so. And stick with me here for a second, but for the most part, I think the clients that we've been working with have adopted a very lean forward type approach to this whole thing. As Jason said, they want to know how they can help. And I think when you're talking about items of supply, given the sort of global nature of the pandemic and how that's disrupting supply chains, how yet it might disrupt supply chains and change the availability of certain critical components or subcomponents, I think that's an area to pay special attention to, right? Understand that you, as a contractor, may have made certifications about where you were getting your sources, your critical supplies on certain end items, and understanding that changes to that supply chain that may be happening in a different part of your organization could impact the accuracy of those statements. And so part of it is sort of making sure that the right hand is talking to the left hand whenever the company makes changes that could impact those certifications.
And from a compliance perspective, I know, Isaac, in your prior life, you did a lot of work on acquisition fraud, and that's actually how some of the folks probably calling in on the line, they may have dealt with you back when you had to work there. And I know you certainly met plenty of outside counsel probably doing that. So from your perspective in your prior work, what are some of the thoughts you have related to some of those compliance concerns that Jason and Alex were talking about?
Yes, I can definitely speak to that, although I'd like to clarify that it was investigating and fighting acquisition fraud, not committing. But when we're talking about contractors wanting to lean forward and seeing a need and taking extra steps or something outside the contract to try to meet this need in an emergency situation, I think it's important for them to remember that the best of intentions only go so far if what you're doing is prohibited by the contract or otherwise contrary to the contract, and if you're not being open and direct about it. So if a contractor believes it can meet an urgent requirement faster by purchasing goods from a getting things sourced from a non-Trade Agreement Act country, it may well wish to do so. However, it'd be best if it notified the government what it was doing, or even got the government's consent, but was always upfront about what was happening. So therefore, if it turns out that the government was not okay with, notwithstanding the circumstances, it was not okay for the contractor to have done that, the contractor won't be faced with a situation where it looks like it was trying to cheat the government and cover it up. One of the things I've experienced repeatedly in my time doing acquisition fraud was that it's not the crime, it's the cover-up that is a contractor's undoing, because mistakes happen. People do the wrong thing, people make the wrong decision, but once you take steps to conceal what you've done, once you falsify a certificate of conformance or make an intentional misstatement to the contracting officer or something like that, that goes from being a mistake that could happen to anyone to being an intentional act where someone made the decision to do the wrong thing. And that's when a contractor's responsibility really comes into question. That's when the penalties start getting a lot harsher. It goes from being an issue of contract compliance, contract interpretation, whether the contractor didn't do what they were supposed to do under the contract, to an issue of fraud, of false statements, of making material misrepresentations to the government, and when you tend to start having criminal investigators get involved. So what I would always encourage, what I encourage my clients to do, even on the government side, is when faced with uncomfortable questions, when they've done something wrong, when there's been a mistake, to acknowledge it, explain the circumstances, and then address what they're going to do to prevent that from recurring. So that way they're not digging themselves in deeper by trying to cover something up and showing that they're willing to be dishonest or commit fraud. I've seen many cases of things that started out as good intentions. Someone thought they could get something for the government cheaper or faster or better by doing it in an unusual way, leaning forward, if you will. And when it turned out to not be the outcome they expected, trying to hide it or cover it up rather than just acknowledging what had happened. And that's ultimately what tends to be the contractor's undoing. And I think that's certainly applicable here, that the government would love to hear ideas for ways to speed things faster, for ways to fight the pandemic. Any kind of, we are open to speaking personally again, but my view is the government's open to any ideas outside the box thinking, but that should be done those should be communicated to the government and done with the government's consent and understanding, not a contractor taking action on its own because it thinks the government will appreciate it down the road. That usually doesn't end well.
I was just going to echo what Isaac said. My experience is exactly the same. And, if you are raising, we're kind of, not to beat the drum too much, but just again, that early identification and discussing the issues, if you do that now, you're going to save yourself. And even though you might have some tough conversations now and working through some of these really difficult, we all acknowledge, there's some really potentially difficult compliance issues to work through here, really difficult. but it is infinitely easier to do them now than it will be to do them when this pandemic is over, and the oversight or the whistleblower community starts bringing False Claims Act allegations, and then you are running to that exact issue that Isaac was just discussing. When did you know about it? How soon did you know about this issue? Why did you bring it to us then? Those kind of issues just make it a lot harder, because that's when people like Alex and myself get called in to help the contractor. Nobody likes to see us show up in those circumstances. And it's your defense counsel in those kind of situations are just in a much more difficult place because you're trying to dig yourself out from potentially, this argument, well, why didn't you bring this to us sooner? We could have dealt with it, blah, 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 blah. And there was some kind of a cover up. So that's, again, I can't, I echo what Isaac said, and I just think it's, the theme here, early identification, work through it now, may be tough, but it'll be, because this pandemic will end. And if, again, Alex and I are here to, we've still bear the scars from litigating, the fallout from the Iraq War. When you're in this situation, I think, the government will come along and see also, so you were hiding this in the midst of this terrible thing. That also is not a story that goes over well with auditors or the enforcement community.
Well, and related to that, some of the questions we've gotten have related to performance questions and dealing with them. And I think it's because contractors are trying to deal with things early on. And, so we'll address a couple of these questions, hopefully, as a group before we kind of close out with some final thoughts on the resources that are out there that are kind of coming out at breakneck speed to some degree as far as dealing with the COVID-19 issues. But one of the questions we had gotten relates to clients asking about reducing their costs, in particular their personnel costs. And some folks, some contractors are trying to figure out how they can reduce salaries under both firm fixed price and labor hour contracts. So if their contractor personnel are salaried and they're providing work under both a firm fixed price contract and a labor hour contract, how have contractors and contracting officers been handling this issue? And this may be something that ends up being a much broader discussion. I suspect the Employment Safety and Labor Committee is going to be dealing with a lot of these questions, and that their April meeting may end up being dedicated to this, as well as the CARES Act and things like that. But I don't know, Jason, Alex, or Isaac, if you guys had any thoughts on anything related to this right now.
Yeah, I mean, my initial reaction was the same as yours, Jayna. I think that a lot of those issues, you think about like Service Contract Act. I mean, if you have, you get into the question of, are these folks exempt or non-exempt personnel? There could be some issues there. That's the thing that immediately comes to mind. But assuming that that's not an issue, if you're now experiencing reduced cost, the question there under the changes clause typically is going to be, is the reduced cost the result of government direction? If the reduced cost is a result of government direction, the government may have an argument that they're entitled to a price reduction. But if the reduced cost is not the result of government direction, there probably is going to be an argument that they're not. So, I think that's, I hate to give the classic lawyer argument of it depends, but, putting aside the labor, the potential DOL issues there, I think that, it's going to really be a question of whether the reduction in cost is driven by a government directed change. And if not, I'm not sure that it's, I don't know that I would immediately see an argument that the labor rates need to go down or the fixed prices need to be changed. But that's kind of an off the cuff reaction.
Yeah, the one caveat there would be if you've got a contract that is set up to allow for such a downward adjustment. So if you think about fixed price economic adjustment type contracts, or where you have other fixed price arrangements that allow for that kind of tailoring, right, to represent or actually capture the cost experience that a contractor is seeing on the contract.
Absolutely.
Any thoughts on your end, Isaac, or should I move on to the next question?
Oh, I think I rest on their answers.
All right. So the next question is also related to performance issues that folks are starting to see. And one of the questions was that a contractor has noted that they're starting to see some customers issue partial or complete suspensions of work, saying that the interruptions aren't going to be addressed as a suspension of work, but would be addressed and treated as authorized under the Sovereign Act doctrine, and that the government customer is not going to pay for any costs associated with the interruption. So, you know, Jason, Alex, Isaac, I don't know if you guys have any thoughts on how to deal with this. You know, and part of the reason the question came about was that, you know, it seems a bit surprising that it's not coming up as a defense, but it's just coming out as a straight out of the gate comment from the government customer. And so I suspect you might have some thoughts on how to address this, Jason and Alex. I can see you smiling, Alex, so I might even punch it over to you first.
I was going to say, Jason and I might jump over each other to try to answer this one, but you know, I'll be quick and let Jason jump in here. You know, short answer, I guess my immediate reaction there is that the Sovereign Acts doctrine doesn't apply where there's a contract clause that allocates the risk of the particular contingency that you're talking about. So if that suspension of work is as a result of something you know, related to a change or related to something that is actually within the government's control, and you've got a contract clause like the suspension of work clause or the stop work clause that you know, dictates the procedures for actually carrying out that type of an adjustment, then that contract clause controls. You can't just throw your hands up in the air and claim sovereign acts.
Yeah, I would say amen to that. I mean, you know, you have a whole, I mean, you know, the clauses Alex mentions, if you get to it, you know, I could even see, you know, invoking, you know, the excusable delay provision as well, which contemplates, you know, epidemics and quarantines and that kind of thing. You know, the notion that the government could rely, because I mean, the Sovereign Acts doctrine is really, you know, if you think about it, is simply just the doctrine of legal impossibility applied to government contracts. You know, and I'd be hard pressed here to think, you know, the real ultimate cause here of what's happening is the virus. It's not like there's been some, you know, legislation passed, you know, that of general applicability that is barring performance, and you know, it's really just the legislation itself that's driving it. That's normally what I think of as the classic Sovereign Acts case. You know, this is not that. This is a government response to the virus. And I, you know, again, I'm with Alex. I mean, there's bunches of contract clauses that allocate, you know, that address and allocate this exact risk. And I, you know, from my perspective, representing contractors, I would push back very hard at the notion that, you know, Sovereign Acts is a escape clause here for the government.
I'm going to tread very carefully because I hope that it's not an agency within the Department of Defense or one of our components that is raising this issue in terminations right now. But I would agree with my colleagues that this is not the sort of situations I would see the Sovereign Acts doctrine applying to. This is not the decision to stop work on these contracts is. I don't see it stemming from, again, in my opinion, I don't see it stemming from the type of circumstances that the Sovereign Acts doctrine applies to. This isn't like Hurricane Katrina flooding the levees. This is very different, and frankly, this, again, speaking personally, this is unlike the way we're trying to work with our contractors. This seems sort of heavy-handed, but again, that's my personal opinion. I don't know the facts or specifics, and I sure hope it's not within DOD, or else someone's going to be upset with me.
Well, and I think really the takeaway that you know, from everybody is possibly something that could be under the Sovereign Act doctrine, but it's surprising, I think, to most folks, and to the person who posed the question to the panel. And I think to that extent, the takeaway here sounds like it's pushing back, trying to get an answer as to why there's a belief that the Sovereign Act doctrine applies, and then pushing back as far as if there's still a disagreement against the parties, or I'm sorry, disagreement between the parties, as far as making sure that that's documented, based on what Jason, you and Alex have been saying earlier, as it's the documentation that's going to carry the weight down the road on these issues when things actually do start going forward, as far as litigation, if that ever has to happen. Jason, Alex, Isaac, one of the last things I wanted to pose to you guys was the resources that you guys have been either relying on or creating or using. What are some of the resources that you guys have been relying on to stay up to date on the impacts? Isaac, I might shoot it over to you to start with that.
Oh, I don't mind starting this. So first of all, I'd like to say that hearing my fellow panelists mention things like the March 30th DPC memo, that's great, because this is guidance being issued by the department that either directly to the defense industrial base or to contracting officers or components. We want to share that information. We want to be transparent about what the department is trying to do. Much like industry, folks working for agencies are in a new uncharted territory. We're also anxious. We also have families that are home if we're not working from home ourselves, and there's no standard operating procedure. We're not turning back to the guidebook from the Spanish flu of 1918 to tell us what to do. So we're trying to figure this out too, and getting out guidance as quickly as we can. We're glad that it's reaching, at least it sounds like it's reaching the community. That being said, one of the main ways I'm staying up to date on impacts is the questions I'm getting from clients. Frequently I'm getting questions, and it's things that hadn't occurred to me or that I wasn't aware were going on, and then I'm quickly scrambling to then try to advise them on it. It keeps me on my toes, and it certainly makes it interesting. There's some really good resources that I check daily to get from the Department of Defense. There's a DoD coronavirus website, which is under the defense.gov domain name. It's defense.gov/explore/spotlight/coronavirus that has good information. Additionally, the Department of Defense Industrial Policy Group, which is part of Acquisition Sustainment, has a great website. It's defensebusiness.gov/coronavirus. They put up lots of policy there, lots of guidance, and then links to things like the DPC coronavirus website, which is not nearly as easy to recite or catchy, but where they've been putting up all of this guidance. And then acquisition.gov also has a good coronavirus website. So I will literally be going to these websites multiple times a day to see if new guidance, frequently stuff I've been chopping on, has been posted, and to see if there's something I've missed that's gone up. Additionally, social media, Reddit, LinkedIn, they've got great information, and they're worth paying attention to.
Yeah, I think a couple of other ones that we've been tracking. As Isaac mentioned, the DPC website I think is particularly good if you're in the DoD space. MITRE has, under the auspices of its acquisition in the digital age IDA program or project, has a page that not only is identifying acquisition policy changes and capturing that information, but also identifying contracting opportunities and also guidance, health guidance being issued by the CDC and other federal government entities. So it's sort of a one-stop shop that I find helpful to think through in a holistic way. And candidly, I think the public contract bar has done a very good job of getting out in front of this issue. I think a lot of the firms that you see, out there are doing some excellent writing, excellent speaking, a lot of good thinking, not only on the issues that are pressing today, but also on those sort of phase 3, phase 4 downstream impacts that contractors are likely to see. So paying attention to what others are saying and leading in this particular section, I think has been especially helpful for me.
And I echo all of that.
All right, so before we sign off, one of the last things I wanted to mention is that this was a webinar the Diversity Committee of the Public Contract Law section had put together, and so I wanted to throw in one pitch for a diversity committee event that's happening next week as well, that is related again to COVID-19, and it's going to be hosted by Agu Anuma, who's at Microsoft, and it's going to be talking about how, or it's going to provide an opportunity for our members to talk about how they're dealing with some of the work-life balance issues that may be coming up. I know some of the speakers on today have young kids, and they are, also playing part-time teacher or part-time daycare provider or part-time something else, pet care provider as well, that we hadn't been used to doing. And so the discussion next week is going to be on the 7th, so on Tuesday, and it's going to allow folks to really have a true discussion amongst members about what they're doing to deal with work-life balance, as well as to just have a little bit of community time to talk, about some of the things they're dealing with from the family side. So I do encourage you guys to attend that to the extent you can. The Diversity Committee had sent out an announcement and registration about that. So please do respond to Agu if you got that. If you did not receive that and have a desire to come, please feel free to shoot me a message and I'll make sure you get signed up for that. Otherwise, I just wanted to thank all of the panelists, Isaac, Jason, Alex. Thank you guys so much for participating today. It was great hearing your perspectives. I know the attendees must have enjoyed it as well. We've had a very high attendance rate that stayed pretty constant throughout the whole time. So I think they really enjoyed hearing what you guys had to say. And thank you again to Abby and Preston for all of what you guys did in helping put this together and brainstorming this great idea. Alex, Jason, Isaac, any final thoughts before we sign off?
Nothing for me, just thank you, and hope everybody is healthy and safe out there.
Same for me.
Thank you for this opportunity. It was great speaking to a large group, and I really enjoyed it. And definitely stay safe, and please have your clients work with the contracting officers. This is something we can all work together as a group. Thank you.